Thanks very much for that introduction. And I'm going to get the mood going by sitting as though I'm comfortable in this chair, in this comfortable chair, and in a way that doesn't reveal to you how enormously tense I am about being on the same stage with the Chief Justice of Canada. And so I just want to say this is not the first occasion I've had to be in the same location as the Chief Justice. Among the many things she does, in addition to helping bring Canada to the just system that we all enjoy, and in addition to representing Canada in the judiciary around the world, she also travels quite extensively across Canada and speaks at law schools, ours included. And it's always a special thrill when the Chief Justice visits any law school, and ours in particular. As you'll hear, she taught at UBC for a period of time. And it's such an enormous gift that she gives in visiting law schools and in being in the same room with law students who are just starting out thinking about their legal careers and what they might do with their legal knowledge and training. And to have had the chance to see students look up at the Chief Justice and ask her questions and feel inspired by her is just an example or a snapshot of the many gifts that she gives back to legal education and to Canada generally. And for us, of course, one particular pleasure was that she made time to attend the opening of Ellard Hall a couple of years ago. And that was a particularly important ceremony for us, and we're grateful, as always, that you were willing to attend. So in terms of our procedures tonight, I'm going to read a little bit from the Chief Justice's bio and then invite her to come forward. And then we'll have a chance to talk a little bit about the procedure, and I use that word for the legal people in the room. For other people, it's how the event's going to unfold. But first, a little bit about the bio. So the Right Honourable Beverley McLachlin is at what would be described in a vast understatement, a long and successful career in the field of law. She practiced in Alberta and British Columbia, and then, as I mentioned earlier, taught at UBC for 7 years. And there are people who still introduce themselves to me at alumni events by saying, yes, I was taught evidence by Beverley McLachlin. And that's always a mark of pride. Her judicial career started in the Vancouver County Court in 1981. She was soon appointed to the Supreme Court of British Columbia and then elevated to the British Columbia Court of Appeal. She was then appointed Chief Justice of the Supreme Court of British Columbia in 1988, and only 7 months later was sworn in as a Justice of the Supreme Court of Canada. And finally, on January 7th, 2000, she became the first woman in Canada to hold the position of Chief Justice of Canada. She is now the longest-serving Chief Justice in Canadian history. In addition to her judicial duties at the Supreme Court, the Chief Justice chairs the Canadian Judicial Council, the Advisory Council of the Order of Canada, and the Board of Governors of the National Judicial Institute. It is with enormous pleasure and only a tiny bit of fear that I welcome the Chief Justice of Canada. Thank you. Well, welcome. As I said, we now get to talk about procedure.
Yes.
Or what's going to happen this evening. So a word about the format of the event. I have in front of me many questions. And the format is that I have a chance to lead a discussion by going through these questions over the next 40 or so minutes. And then we have an opportunity, we hope, to have questions from you, members of the audience. And so, in addition to listening with rapt attention, and this rare opportunity to hear the Chief Justice's remarks, I encourage you to be thinking about a question that you might want to ask that would benefit you and benefit the other attendees at this event. Now, after the discussion, and I had to actually get a piece of information about this, there's going to be a reception at Beercraft across the way. And I have confirmed that that's actually how you pronounce Beercraft. And I'm so unfamiliar with these things that I had to check. As Ashley mentioned, we're also recording the evening so that the conversation can be online and enjoyed later. And the video will be available on Alumni UBC's digital library at www.alumni.ubc.ca. So we're now ready to start the fun. Now, this is the point where I tell you that the questions we sent you in advance, we've thrown away.
Why am I not surprised?
Yeah. I think people would be curious, having heard about your many accomplishments, to know when you first thought about actually having a career in law.
Well, it was rather late on. I certainly didn't grow up thinking I was going to be a lawyer. There weren't any lawyers in the little town where I grew up, and legal issues didn't loom too large. We left our doors unlocked at night, and there was little crime or fear, but and not even much commercial kind of law going on. But when I went to university, I studied philosophy. I did an undergraduate, and then I was trying to decide what to do next. I was thinking of doing graduate work, but I found myself less and less drawn that way, and I thought, well, what else could I do? And isn't that an inauspicious start? Any event, I was discussing this with a friend, and he said, I think you'd be a good lawyer. So when I was home at our ranch during the summer after I had graduated from philosophy, and I thought, I'll just write a letter to the Dean of Law, whom I had known who he was. I didn't know him. And so I wrote, Dear Dean Bowker, could you give me some information on attending law school? And he wrote back by return post, you're accepted. So when September came and I was still dithering, I said, well, I'll go up and see what it's like. And from my first week, I thought, this is really what I want to do. And so after that, I was committed to a career in law.
Well, that's a great story. It's not precisely how law school admissions work today, but
no.
You could, I think we'd all agree, achieve no finer result than that admissions process achieved for the University of Alberta. So to flash forward, that's your sort of experience of how you became a law student, but you're also a law professor. And as a law professor for 7 years, did teaching the law change your outlook or perspective in any way?
Well, that question was on the list, and I thought about it. I thought it was an interesting question. I guess it probably did. I was doing mostly civil litigation before, and you're zoning in on solving a particular problem or writing a particular factum or preparing a particular argument. But law school requires you to take an overview of whatever you're teaching. And my main subject was evidence, and I really got passionate about the whole business of procedure, even in the criminal law, which is the main part of evidence. And I loved that subject. I didn't ever think I would become a judge, but looking back, I think that I could not have had a better preparation for it than being a teacher at a law school. I taught evidence, which was terrific because, as you know, one of the things you have to do right off the bat is run trials, including criminal trials, and it's nice to know the hearsay rule and this and that and the other thing, and what the cases are. So that was a great help to me. And then I also taught just about everything else that no one else would teach, like creditors' remedies. And someone said to me once, why were you so unstrategic in your legal teaching career? And I said, well, of course I knew I was going to be a judge, and I had to learn all of this stuff, and which was absolutely not the truth. But the first time I got into a chambers, I had a chambers day as you know, a trial judge. You all have to take your turn in chambers, which is just one application after the other, a lot of them having to do with mortgages and creditors' remedies and other esoteric topics. And I thought, now I know why I did all that. No, law school teaching law school was great for a lot of reasons. First of all, you have to take a big view of the subject and look at the problems from all directions. And that's very good for someone who's going to be a judge. The academic approach to things is really, really helpful, I think for judges. Another thing, I think, was just getting to know students as well. How did that change me? Well, it sort of humanized, even more than I had been, the law for me, to see how people came into the law for so many different reasons, from idealistic to very commercial and so on and so forth, and helped me understand the future generation of lawyers coming up and the way the profession would work. And it's a great pleasure, even now, I'll go to events and people say, well, you taught me this or that, this isn't actually answering your question how it changed my outlook, but it certainly is how it enriched my life.
That's a great, fascinating answer. And, you know, we've talked about you as a student, talked a little bit about you as a faculty member at UBC. And, of course, in that introduction, I recounted what's usually described as the meteoric rise through the judiciary for our guests this evening, serving at these varying levels of court and moving eventually to the role as Chief Justice of Canada. And I guess just thinking about that enormous success that you've had, do you think that that's influenced people in some way, seeing what you've been able to accomplish through the sort of arc of your career?
One of the things that's amazed me in a way is how people, especially women and young girls, need role models. And I always thought that was a rather peripheral thing and so on. But particularly when I got to the Supreme Court of Canada, I realized how important it was. I got letters. I would show up on Canada Day in the Supreme Court, and people would bring their children, and they were so thrilled to be able to tell them, you know, that this is our Chief Justice, this is a woman. The little girls would look up, and over the years, those first few years as Chief Justice, I really realized, in a way I hadn't before, how maybe one of the most important things that was happening was that people were taking confidence from the fact that a woman who came from no particular background, just worked her way up in this country, could get to the highest position. For many people who come to the court, these groups, you know, from different ethnic communities, they've come from countries where women never had a chance, and they can say to their daughter, look, this is what can happen in Canada. And it is really, really important. It may sound trite, but it is a very important thing.
Well, you've touched on this in a way in your answer to the last question. But I guess one of the questions that people had when they were thinking about your career was, what would you be most proud of being a justice or of being a woman justice on the Supreme Court of Canada? Is that something that's possible to distinguish in your mind?
If I can dodge the question a bit, I really have trouble dissociating the two because I am a woman Chief Justice, and I'm not really in a position to say either or. I think I've never liked either or questions. I think that they're both important. I mean, I assume that what the question's getting at, and you can correct me, is the fact that I'm a woman as important as the fact that I'm there doing the job. And I always think that the job, in my own mind, is the big responsibility in what I do. But I do it as a woman, and therefore I would not know any other way to do it. Does it make a difference? I don't know, but it's who I am. And so I have a little difficulty answering either or on that one.
Mm-hmm. No, it's understandable. So we talked about your serving as the longest-serving Chief Justice in Canada, and there's so many different roles that you serve as Chief Justice, in individual cases, and then for the court, and representing Canada in different contexts, and the courts in different contexts. If you had to consider maybe 3 things that you felt most proud of as accomplishments in your role as Chief Justice, do some things stand out?
Well, I think by far the most important is being able to have made a mark on the law in certain areas and maybe advance society or people's rights in some ways. This, I think, is what I would take great satisfaction in. The second thing I think I take some satisfaction in, and I don't claim credit, but you're just saying, what are the good things that you think may have happened? I've had the privilege to work on a number of courts, starting with the county court in British Columbia, and then the trial court, and then the Court of Appeal, and then I was briefly Chief Justice of the Trial Division, and then on to Supreme Court of Canada. And it's been really, really gratifying to contribute in a small way to how those courts actually administer justice, everything from access to justice to making sure the hearings are fair and the judgments get out. And in our court, the Supreme Court of Canada, where we have 9 people on some of the most difficult issues that can arise, legal issues, and often face divisions. They're all really difficult issues. One of the things I work the hardest at, and I take a lot of satisfaction when it works out, is trying to get a really, really good discussion on the cases and to eliminate the things that might divide us that we can avoid or that we don't really matter, and get us together on the main points and keep people talking to each other and dialoguing so that we can come up with the best answers we can come up with. I'm not saying we're perfect, we make mistakes, but that is the process. And I want to feel that that process is working well. So I would say that's the second thing that I really would take some satisfaction in. And perhaps the third would be the helping Canadians and others just to understand and the justice system and what we are trying to do in the justice system, what our responsibilities are, this outreach role, if you wish. And I've enjoyed that a lot, and I've found huge responsiveness in Canadian audiences who are interested in the justice system, sometimes critical of it, and rightly so. But that outreach, making the courts more accessible, making the courts better known. As you know, we televise our hearings, and we webcast, live stream. All the justices go out and talk to legal groups and school groups and other groups. I think that's very important. I think the people of Canada are entitled to know who their judges are and how their court systems work. And so I take satisfaction in that.
You know, you touched as a part of that answer in the fact that you're Chief Justice and you work with other justices and you're confronting oftentimes really complex and difficult issues. If an issue makes its way to the Supreme Court of Canada, it's often not only deeply important to the people whose specific claim is before the court, but often the case raises big, important issues, whether or not they're about line of business and whether or not it will succeed or fail within Canada, or whether or not it touches on human rights or other topics. And you've talked about the fact that the justices don't always agree, and that there's a process for trying to hone in on the key issues that must be resolved. And in the end, the court's decision, its judgment, you'll oftentimes have more than one justice writing about how to resolve the case. And so when it comes to the judicial process, there's a very public way of dealing with a contentious issue, and for different opinions to be expressed by the justices, oftentimes diametrically opposed, sometimes agreeing in some areas and disagreeing in others. And it puts those, both the agreements and the disagreements about these key issues, out for public scrutiny, so that we can all see how the court has responded to a particular complex issue. And I guess I wondered whether or not there's anything about that process, the process that you as justices go through in trying to hone in on what the issues are and how you go about expressing what you feel is the right way to resolve the issue, and being exposed to public scrutiny in doing that. If there's anything about that that's useful in other areas of society that you think is,
Yeah. Well, when I first came to the court, I remember something that the first woman on the court, the Supreme Court of Canada, Bertha Wilson, said, and she said, people of Canada are not just entitled to 9 different views on the issue, 9 different votes. They're entitled to 9 different views or votes after each of the justices has considered the views of all the others. And that, to me, is key. She said it very, very well. So this may be the takeaway, perhaps, for other dispute resolving or other challenges people have in different areas. I think listening, even if you reserve the right to disagree, is very important in every area of life, from family life right on up. And that is what we have to practice, we try to practice in our court. And when courts are working well, courts of appeal, they are listening to each other. The judges are listening to each other. They're engaging in dialogue and conversation, and they may not agree and they may passionately disagree, but they have to be respectfully listening and coming back. And if we could just cultivate that practice of respectful listening, and I think many people, many organizations do it, it's a good thing, and it's a good way forward.
So I'm going to return to the topic of gender for a moment and say that last month the gender balance on the Supreme Court went back to 5 men, 4 women, when Madame Justice Suzanne Cote was sworn in. And how does the gender balance affect the court, and if so, how?
Well, it's a very difficult question to answer. I feel, there is definitely a difference between sitting on a court with 3 or 4 women of 9, for example, than there is from being the only woman on a court, as I was in British Columbia Court of Appeal for a while. I mean, I didn't have any particular difficulties. Everything was... I was warmly welcomed, and I got along very well with all the justices there. But nevertheless, there's just a comfort zone that I find anyway when you get near parity. And other people have also noted this in academic literature, that it doesn't have to be half, but conversations start to change in organizations when you get around a third or a quarter, but a third to a half is usually the... And how do they change? I don't know. All the women on our court are first and foremost lawyers. They prepare the same way. They see the issues, perhaps different ways, but you can't say she's seeing it that way because she's a woman. But I have had experiences, I can say, and I can't give the specifics because we never reveal what we discuss about cases, particular cases, but I've had experiences where I've seen a woman, in some cases myself, bringing a slightly different perspective to a problem that may involve a woman's situation or a family situation, that will bring that perspective into the discussion where it may not have got into the discussion before. So I think even in a concrete way, it really, really, it's a good thing. Apart from the fact that we hope that our major institutions reflect the makeup of our society, more or less. I remember being in trial court one afternoon in British Columbia here, and it was a very simple matrimonial division case, and the wife was there with a female lawyer, and the clerk was female, and the court reporter was female and I was female, and this lone man was standing up behind the other table all by himself. And so they had a townhouse and a car, and they decided on custody, so that wasn't a problem. They had a few other things, and so I listened to the wife's lawyer evidence and what her, and then I turned to the husband and I said, well, now I'd like to hear your side of the story. And he seemed to be having trouble getting up, and I thought it was because he wasn't represented by a lawyer. And I said, well, you know, the fact you don't have a lawyer doesn't shouldn't worry you. It's a fairly straightforward case, and I just need to hear what you have to say about the facts and what your wife has said. And finally he got up and he said, with a great tone of umbrage, frankly, Your Honor, I feel a little outnumbered. And I assured him that the fact that he was a man wouldn't be held against him, and we divided the property 50-50, and I went home, and after dinner, I started reflecting on my day, and I thought, that was really interesting. I said, how many times has a woman, if they ever got there, and this was many years ago, stood up before an all-male array of judges, or maybe just one judge and everybody else male, and felt a little outnumbered? And that changed the way I looked at these things. I said, we have to get women in these pivotal institutions so women feel comfortable going there, so they feel it's their court and not, you know, some of these people are not necessarily thinking men have always been fair to them. They need to feel that they're going to get a fair shake. So I sometimes I feel that it's important that we have women everywhere, but certainly on our bench.
So I want to pick up on one thing that you said in that very interesting answer, and then tie it to some references that we made earlier to your commitments around the court. And you talked about the process of decision-making, and you noted that there are things that aren't shared about how the judges interact and things that are said as you're considering cases. And you've also been a very significant proponent of transparency for the courts and the judicial system. And you spoke in an earlier answer about the steps that the court has taken to make sure that the public is aware of what is being argued before the court, what the questions are, what the issues are, having an opportunity even to hear the arguments. So you've played a very significant role in opening up the courts through those technical measures, through your own personal efforts, and going to speak to groups, and really creating this openness about the court and its operation, so that the public can be engaged and can know what's happening before the court. And I guess, by and large, we'd say transparency automatically is a good thing, and public knowledge is a good thing about the court's operations. And I guess I wondered if you wanted to reflect on that, and reflect as well on whether or not there are any risks to that kind of transparency, and to risks to these efforts to draw greater public attention to the work of the courts and the decisions that are being made in the court. And I guess the common idea is to refer to the United States and to say, well, there's a jurisdiction where there is great public focus on the Supreme Court, and that has benefits and risks. And do we see any of those same factors at play in with transparency in the courts and public attention?
Yeah, well, we are probably more open than the United States Supreme Court in the sense that they don't allow their proceedings to be televised and that kind of thing. But I think, like us, they're committed to basically telling the public what they're deciding and why they're deciding it, which is the basic thing. Are there risks? When I started as a judge, there was a view that somehow demystifying the judiciary would come at the cost of making it seem ordinary and increasing criticism and maybe banalizing the whole business of justice. There was something mysterious, sacrosanct about justice as we came off the Victorian era and into the 20th century. And many judges still believed that we had to maintain that aura of mystery. I don't really agree with that. I don't see that. We now are much more open, and I think the public appreciates it, and I haven't seen a lot of downside. There are things you shouldn't, I think, discuss, which is, as you mentioned, I would never go blow by blow through all the deliberations behind doors before we get to a decision. And that there's a very good reason for that, and that is that we have to be able, as colleagues, to speak very, very freely, and we have to be able to change our positions. That's the whole, that happens. We get persuaded one way or another. We might say something at some point and then later realize, no, we went too far. So if you actually made all those deliberations somehow public, if you could, I think that you would put a chill on the discussion. So in order to have an open discussion, we don't disclose our pre-judgment deliberations. So we try to draw the lines where we should draw them. There are things I don't engage in. There are most judges don't do a lot of fundraising. They don't obviously speak on political issues. It's not a cone of silence that descends on one when one becomes a judge, but there definitely is a cone of prudence, and you have to be careful what you say, and you have to be careful to be respectful at all times of other branches of governance, of the litigants and lawyers who may have come before you, and to uphold the respect that the Canadian public, you hope, has in the judiciary.
Well, one of the areas where you've been quite vocal in speaking to the public and working in different ways is on the topic of access to justice. And you have a strong commitment to access to justice, and it's often a theme in your remarks with the public. And I guess I just wondered, for us in this audience, are there particular areas of access to justice or challenges that you would want us to have in mind? And are there things that the public should be thinking about in terms of improving access to justice moving forward?
Yeah. I think we have, first of all, a bit of background. We have a great justice system in Canada, and we need to keep it. And I think if we don't provide access to justice, we will be in danger of marginalizing the justice system, maybe losing it, and we have to be able to keep it open, not only to people of wealth and large corporations, but to ordinary women, men, families, small business people, whatever. So it's that democratic view of justice that I think is important to promote. So people feel that they can go to their court and have a judge listen to their problem and bring justice to the issue. So to me, this is so fundamental, and I feel that we need to really work on it, because there are a lot of pressures, and we see them even more in other countries, which are making justice less and less accessible. The cost of legal services, sometimes even the cost of filing fees and witness fees and things like this can be a deterrent. As I've said before, I think it's a difficult problem, but it's multifaceted, and government, courts, judges, lawyers, all have to, organizations involved with the administration of justice all have to work together if we're going to deal with it. There's no magic solution. But, I've been so encouraged. When I gave my first talk on this in Toronto, I didn't think that it would attract much attention. And it was one of those issues that people responded to. There was a little story in a couple of the newspapers in Toronto, and suddenly there were letters to the editor coming in, there were editorials, it was like we had touched a nerve. There were a lot of people out there concerned about access to justice, and nobody was really talking about it. And at that point, I realized that the problem was perhaps much bigger than I in my cloistered judicial office had realized. And people started responding, and one of my colleagues, Justice Cromwell, has headed up a series of initiatives right across the country, looking into ways that we can improve access to justice in the civil and family area. And I've been amazed at the response, and actually not only the response initially, but at the concrete measures that people are willing to take. There's an increase, a lot of people more interested in pro bono in the law firms. It's getting to be part of what one does in a law firm. Legal aid is still a challenge, but I think the message is out there that people do have to have legal representation. The governments are starting to get interested in it, and actually provincial and federal, there are a number of initiatives that are happening. So I think that we'll never solve the problem completely, but we really have an understanding now in Canada that it's important, and we have a commitment by a host of people at all levels to making things better. So I'm quite encouraged.
Well, let me pick up on what was just obviously a quite broad and thoughtful answer about a complicated issue, where on the one hand, as Canadians, we feel proud of a judicial system that's confronted so many tough issues and helped a society deal with those issues, and that also works very hard to deliver justice to individual people in cases big or small throughout the country. So there's much to be proud of. Challenges, as you've talked about, with access to justice being on the top of the list. But you talked about internationally and some of these problems being shared internationally. And I guess I wondered, what's your sense of how Canada and our justice system is viewed in the world, and what do you, as Chief Justice of Canada, do in relation to judges elsewhere? We talk about the rule of law.
The answer to the first question seems to be pretty well. There's World Jurist Association, which is sponsored by the ABA, but really is an international organization now, and they've come up with some very sophisticated studies for measuring, ranking justice systems, and Canada's comes out very well. Tellingly, the one area we lag a bit in, we are amongst the best in the world, there's no doubt about that, but we lag a bit on delays and costs, so that's telling us something. But we do have a wonderful justice system. The second part of the question is what, sorry.
Do you play a role in helping promote the rule of law generally, and justice
well,
as a challenge?
I try to in such small ways as I may. I'm an honorary fellow of the World Jurist Association, and I give some support. By every 2 years or so, I go to an international meeting where we meet with other justices and so on, and also participate in the Commonwealth organizations for jurists. We participate in the Francophonie, which is the French equivalent. We have exchanges in our court with other courts like the United States Supreme Court and the UK Supreme Court, and in all these ways we try to learn from others, and they are very interested in learning from us often. So, and we discuss the sort of problems that we are all facing in bringing justice to the people in our countries.
I know we're running short on time, and we've touched on many things in the course of the conversation so far this evening, starting from kind of your career and your path to some big picture questions and issues about the judicial system and your role within it. And maybe the best way to conclude this portion of the evening is to try and tie those two together, thinking back on your story of when girls visit the court and look at you as a woman Chief Justice of Canada, and just think about the idea of mentoring and inspiration, and whether or not that's something, with everything else you're juggling, you find that you're able to, yes, inspire people in this setting, but also engage in mentoring, and whether or not, what's the biggest question you're asked as a mentor, perhaps how to become Chief Justice of Canada, but maybe something.
Well,
broader.
usually one thinks of mentoring in the workplace, and I have every year 3 brilliant young lawyers, law graduates, who clerk for me, and I suppose for them, I'm a mentor. I try to be. I don't always feel I'm doing an adequate job of it, but I find that one of the most gratifying parts of the role, just in subtle ways and sometimes not so subtle, teaching them or saying, no, we don't do things that way, or yes, this was great. You have great strengths here, but you could maybe concentrate on bringing up something else. And I find them very open and responsive, and it's not easy mentoring. It's very easy just to go through being an employer, quote unquote, and just say, well, I'm busy, I don't have much time. I'll just get them to do me a memo, and then I'll say thank you, and away it'll go. But it's one of the most satisfying things you can do, and it's often about asking questions too. It's not just about, here's my little shtick and this is what you have to do to be successful, but you have to actually find out something about the person, understand where they're coming from, where their strengths and weaknesses are. And I'll sometimes say, they'll come to me, my law clerks will come to me, and they'll want to have lunch 2 years after or 3 years after, and they want to just talk over a career choice they need to make, or a decision they have to make in their life. And I'm very honored that they feel they want to come and just talk to me about it. I don't usually have a prescription, but I sometimes can say, well, I know you well, I know where your strengths are, I think maybe you should prefer this choice over the other or whatever. But it's a very satisfying role, and we keep in touch with our law clerks, and every 5 years we have a law clerks reunion, and now I've been there so long, there are hundreds of them, and they have thousands of kids, and well, not quite, but they've been quite prolific, and I'm very happy about that. And so Frank and I host a big barbecue in our backyard, and everybody comes by over a period of about 5 hours at brunch, really, and we get to see them all again, and it's such a pleasure. We really, really enjoy it, and it's like having an extended family.
Yeah. Well, I can picture all of them lined up with their life questions and their kids, and certainly for those clerks that I've had a chance to run into, the kind of impact that you see in the course of an evening, having a chance to have access to the wisdom and perspective of the Chief Justice. You can imagine having that over a concentrated period over a year, what a transforming experience it is for the young law graduates who have the opportunity to work with you. Well, we now have that opportunity I mentioned at the outset for questions from you. And we have 2 people with microphones. Christina and Emma have microphones. And did you want me to call on people, or did you want to call on people yourself?
Whatever you think works. I can do it if
that's
you want.
Fine. That's fine, if you feel comfortable.
Sure.
All right.
Who's going to be the first?
Yeah.
No. I get enough questions from him at home.
There was one actually you're talking about, which is strictly on the side of the law and the courts. But there's another life that you have, and nothing's been touched on that yet. I think it's very interesting to tell the people exactly, that you're not wedded solely to law. There are other
I'm wedded to him.
Just remember that.
Well, I think that's an important point. When I became a justice, I was replacing Justice McIntyre, a very, very respected judge from British Columbia, just passed away sadly a few years ago, and a wonderful man. And he was still at the courthouse and so on when I came, and he was very kind to me. And I remember asking him, if you had one piece of advice you'd give me about this new role, what would it be? And he thought about it and he looked at me. I thought he'd say, you have to work hard, or you should, this is how you can deal with your colleagues when they don't agree, or, have something in the professional area. But no, he said, find some outside interests, otherwise this job will consume you. I'll never forget those words. He used exactly those words. And it is very true. It's easy to, with a job like the Supreme Court of Canada, where there's so much work and it's constant and interesting questions and it's important, and you can get completely consumed by it. Now, why is that a bad thing? Maybe for some people it isn't, but for a lot of people, I think, and I'm one of them, you need to have a balance in your life. You need to be able to get some distance from the problems that you're wrestling with. And so this was very good advice, and I have had no difficulty taking it, although there are times perhaps I seem more consumed than others, at least in my husband's eyes. But to go off for a walk on the weekend, or go up to the cottage if you have one, and just wander around, you'll find that that's the time that the solutions to the problems you're facing will often come. You need a bit, at least I do, and I think this is true for a lot of people, you need a bit of getting away from the immediacy of the problem, getting the perspective, just thinking about other things, then you come back refreshed. And I think outside interests do that. For me, I have a lot of interests. I love my garden, I cook a little, I read a lot of books, I go to concerts, I really love music, classical music particularly, and opera. So these things are all ways for me to get away from the immediacy of the problem, maintain your kind of psychological poise, and come back refreshed to deal with the problems energized. That's my husband's question now.
Hello. I'm somebody who's passionate about technology, and I have a question about how technology could affect law.
Yes.
And with artificial intelligence, and particularly self-driving cars, there's been a lot of press lately. And at least for myself, I believe in 10 or 15 years, our roads will be full of self-driving cars, which will not violate traffic rules and will not cause auto accidents. Mm-hmm. So what would we do with all the lawyers?
We'd free them up for bigger questions.
I have a question about after the court issues a decision, do the justices track the decision at all and see how it's been followed and applied and interpreted in the lower courts? And if they do, are there any cringe-worthy moments?
The answer to the first question is certainly I don't. I might note in the press how that this case has come up in a different context or whatever, and it's been interpreted in this way. But I really don't make an effort to follow, and there's a good reason for that. I can't. You really have to. There's so much work. You have to turn the page and move on. And that is one lesson I learned early on in being a judge, even as a trial judge. You cannot sit there and keep second-guessing whether you made the right decision. The work keeps coming on. You have to do your very best within the time allotted to make the best decision you can. And then you can say, I've done it. And then you have to turn the page and move on to the next case. And that is what I do anyway. Are there cringing moments? I suppose I can't think of too many, but I can't think of any cringing moments. Perhaps you have the thought, well, did we really make the right decision in that case? But it doesn't last long. No, the fact is, you know that you're mortal, you're a human being, and you did your best. And the nice thing about our law is that it's a bit flexible. There are new cases coming along, and if a decision is really unworkable, and we've had a couple of instances where lawyers have come to us and said, what you've set out here just isn't working, well, then we have another look at it. And you know, it can adapt and adjust, plus Parliament can change things, and legislatures can draft new laws. So there's lots of ways to get around bad results in the law as a whole. One worries, obviously, particularly as a trial judge and so on, about the impact on the individual. You really hope for that person's life, for their sake, that you've made the right decision. And this is a heavy burden that trial judges in particular bear. Sentencing, family matters are particularly difficult emotionally for, I don't know if Chief Justice Hingston agrees with me, but I think most of the judges will tell you they worry these problems and maybe second guess a bit, did I make the right decision? But that's the job.
Hi. I'm currently an articling student here in British Columbia. This practice of law is actually my third career. And I'm also applying for membership of the Bar of the State of New York. And in terms of access to justice, the State of New York now requires, and this is a brand new requirement, for new members who are applying for membership to the Bar to complete 50 hours of pro bono work in order to be eligible to be a member of the New York State Bar. And my question is, do you think that there may be value in legislating that sort of thing in here as well, where there's an actual requirement for pro bono work? And then the part two question is, does it make sense that it should be for the new lawyers coming in, or does it make more sense that the more senior people should also be involved in that?
So just a question, presumably you're talking about legal pro bono, so they wouldn't be doing this until after they're admitted?
Well, yes, the idea being that, as for example, here's an articling student, you would be required to complete some pro bono hours during that. The way it works in the state of New York is that you are also practicing either as a student or as a student at law or under the supervision of a lawyer, but that somehow you have to require that you have to finish those 50 hours of pro bono work before you can be a full member.
Well, I don't know whether legislative solutions are the best. I do think we need to find ways to encourage people to do more pro bono, and if they say it's necessary to legislate it, perhaps they have arguments. We haven't had any discussion around that yet. Here, I think we look to the profession to regulate itself, that would be for the British Columbia legislature to decide, I guess. But my answer is I think we need to find ways to encourage people. But you asked, should it be the young people or the senior people? I think pro bono is really good for young people in that it gives them an exposure to sometimes court time. They get into court in cases where they otherwise wouldn't, and they get experience in the trenches dealing with clients that they might otherwise not. So it's a good thing for young people, but ideally they should be working with somebody a little more senior, I think, because they're inexperienced at that point, and the client has to be taken into, client's interests have to be looked after too, and so I think it's a combination that you need you certainly need some senior people, and we should have quite a bit of senior buy-in. We see what I suspect is quite a bit of some significant amount of pro bono work in our court from senior counsel who will take on a social issue or something, and you can pretty much figure out that there isn't a lot of money behind this, but they must be taking it because they want to see this issue argued and so on. So I'm hoping that we have a system where we have a mix of everyone working on pro bono files.
Thanks. And just, everybody has done this thus far, but I looked down and saw that I forgot to say that in addition to asking a brief question, if you could introduce yourself and say a little bit about who you are before you ask. Everybody's done it, but let me insert my...
Hi. First of all, it's an honor, Ms. McLachlin. My name is Vincent, and I am a teacher on his practicum, and one of the subjects that I teach is law, and I teach senior high school students. So I guess my question, from one teacher of law to a former teacher of law, is what are some important things about law that I should seek to impress upon my students, or how would you advise me to approach the teaching of law?
Wow. Well, I think you could start from the rule, just off the top of my head. I've never had that question before, but I would think that I'd want to explain to the students the importance of law in society and the rule of law and what courts do and how they basically function, how the legal system functions. But also from a political science perspective, the importance of the rule of law to a democratic society so that they understand that we have three branches of governance, legislative, executive, and judicial. And what is the function of the judicial branch of government? What do judges really do? What is the concept of impartiality in the judge? What does it mean to have an independent judiciary where a person can come and be against the government and expect the judge to give a fair shake? If you could get those ideas through to the students, I think it would be a great thing. There's a video that was produced by the Association of Judges a few years back for high school students, which is used sometimes in teaching high school students. And it's really quite interesting. They take examples. For example, a young student, teenager, is going to a rock concert with a backpack and leaves it at the desk as he is obliged to do, and then when he comes back, takes it, and then he is stopped by the police and they find a drug in it, and therefore he's charged. He says, I didn't know anything about that. So they take him through the stages of what his rights would be. Would you like to have a lawyer? What kind of a judge? Partial, impartial, paid by the government, or in the government's control, or all of those basic issues get worked through in the course of that little video. So by the time the student has got through it, he understands why he might that he has the right to silence, why he has the right to a lawyer before he pleads or makes a statement to the police. He can get legal advice. That if it comes to a trial, he's entitled to an impartial judge. You can see how a student would work through an example like that, and all of the issues I started off by talking about would be worked into the example. So those are just some ideas off the top of my head. Good luck.
My name is John Weckman, and I know absolutely nothing about legalities of legal aside from watching Boston Legal. And my question is, how is the case presented to you, and what's the protocol, the process till the very end? Do you get the Globe of Mail, and then the secretary says, here's not a case, and what happens from then on?
It doesn't have much to do with the Globe and Mail. What happens is that cases start in a trial court, and then they go to the Provincial Court of Appeal, and then usually with leave, but there are a few situations where you can come as of right in the criminal area, we grant leave, and we grant leave to appeal on questions of public importance. So we only hear about 85 cases a year, 80 to 85, 75 to 85 is more accurate. And those are mainly questions which we have vetted. The judges look at them, and we have decided that there's there's a legal issue of public importance. And so we take that issue, and then the lawyers file factums, and after that is briefs of argument. And sometimes there are interveners, that is, members of the public or who are interested in some aspect of the question. They can file their briefs. And then we have a hearing, which is scheduled. Usually 9 judges sit, or 7, sometimes 5. But we usually try to sit 9 or 7. We have the hearing. After the hearing, we go out and talk about the case. We decide more or less where we are. The Chief Justice names someone to write for the majority, and in due course that person circulates their reasons. People comment on the reasons. They decide whether to agree or not. They have the right to write their own reasons. Ultimately, it all gets sorted out where people are, and we publish the judgments in both official languages, and they go out. And that's the process. I don't know if that answers your question.
But that answers the question.
Thank you.
Good evening, Your Honor. I'm Don from Law Court Center. I'm a teacher too. I have a question on culture. How do you see culture coloring the courts?
The courts? Well, culture is such a big thing. Most of our lawsuits have some sort of cultural aspect to them, and you know, I couldn't begin to number the ways that the cultural issues come before the court. Be they matters, you know, one in the news right now is religious dress in the courts, and I'm not going there. But we see culture in all its manifestations in the court. Now, if you're talking about culture, the multicultural nature of Canada, we obviously see ramifications of that in our constitutional interpretations. I'm hoping that gradually we have more minority culture representation on our courts. I'm not quite sure I'm answering your question, but these are some of the thoughts I have.
Great. Thank you. Hello, Chief Justice. Anne Giardini, UBC Law alum from '84. You mentioned earlier the importance of listening as a judge. Mm-hmm. And this comes up for lawyers, too. We have to listen to clients, and judges have to listen to people that come before them. One lawyer I know has called this the ethical duty to listen. And I'm just wondering how you ensure that the litigants who come before you feel heard, what you do to make sure that happens.
Well, we don't give them much time. We have had to, it was as long before I was in charge, but the court, after the charter was adopted in '82, just found it was facing a huge amount of work, and so there was quite a procedural overhaul. And as a result, the rule is, and we do depart from it sometimes, that we allow an hour to each side to make oral representations. So that's the main way, I suppose, that litigants feel heard. Their lawyers come to court, their lawyers talk to the judges, they had questions. Now, questions from the judges show that the judges have engaged with the case. But I should say the process starts well before then. The first way the lawyer makes the client heard is by presenting a good brief. And we all read the factums before we go in. And so we have digested what each party has to say. We should know before we go in the courtroom what your clients are contending, what their position is, and therefore the hour hearing that we have is mainly to have a conversation, a discussion, to listen, of course, to what the lawyers say. But since we've already read the factums, we already know the facts, we already know the main cases they're relying on, we have a pretty good sense of where the real issues are. We often want to focus in on those issues. But our goal is, through these various ways of listening, quote unquote, be they through documents or be they oral, that we really, really thoroughly understand each party's situation and each party's position. And the lawyer is the mouthpiece who helps us do that.
Hi, my name is Andrea Wenham, and I'm a policy analyst with the Government of Canada, so I'm very interested in the relationship between the government and the courts. I know you said earlier that, pardon me, that the court doesn't comment on the government, but I was wondering if in a general sense, you had any views on whether or not over time the relationship between the court and the government changes, or whether or not that's something that remains static?
No, I really don't think. I think that the courts are very independent in our country, and always have been. And we don't really have relations with governments in the ordinary sense. Obviously, courts have to be supported. So we need to get enough money to run our operations. But apart from that, we do our thing. We do it as impartially as we can, and we've always done that. And that's the end of it.
It's an honor to meet you, Justice McLachlin. UBC Zoology 2009. I am a biologist, and I have a question. David Suzuki, Dr. Suzuki, UBC Emeritus of Zoology, has been recently campaigning to put forward a motion to have the Charter of Rights and Freedoms include the right to a healthy environment. And he's been doing it on a grassroots level, getting municipalities to adopt it on a local government's level and bring it up. And I wondered what you thought about that.
Oh. Well, I'm all for the environment, but I don't think I can comment on whether it should become a charter right. That would be up to the people, the premiers of our provinces and the prime minister of this country, and what they want, whether they want to amend our constitution. And I think I'm sorry, but I'm going to have to leave it at that.
Yeah.
My question was similar to a previous one, but I'm Gil Kimmel, and I study medicine at UBC, and it's really an honor to be here and to hear what you have to say. But my question was really, and it may seem a little naive, but I'm just curious if you interact a lot with the Prime Minister and how that would be.
No.
No, okay.
Thank you, Chief Justice, for coming here tonight. My name is Rosita, and I'm an educator. So my question is, could you comment on the demands of parenting and raising a family in the context of a career such as yours?
I don't know what I can say of great significance, but I'm a mother, and understand how difficult it is for mothers and fathers to juggle demanding careers with parenthood. And yet I think it's essential that we do it. And I think my own view is if we do it with love and compassion and do our best, it'll probably all come out right, and we shouldn't guilt ourselves too much. I remember saying to my son when he was well growing up, and I was in a ruminative mood, and I said, I remember those evenings when I wasn't at home or wasn't there for you, and I started beating myself. And he said, stop it. He said, you were a good mother, everything was fine. So, you know, whether I was or not, I still have a wonderful relationship with my child. And I think you invest in relationships. Obviously, it takes some time. You do have to make time, and you have to make sure that you're communicating and teaching and showing the child that you love it. But kids are pretty forgiving, I've discovered. Thank goodness. If they feel you're trying your best, you make the odd mistake, you're gone a little bit too much, but if they feel that you really love them and that you're there for them to guide them on the critical things, and that's important. You're staying in touch all the time. Even if you're not there, you stay in touch. There's a certain accountability that takes place, even if it's the end of the day and you pick up the child from daycare and you say, how did your day go? Yeah. How did you sit on the chair? Well, the child knows that you care. If you just pick up the child and just open the newspaper, maybe the child doesn't know. But I wasn't really here to give a lecture on parenting, and I'm no expert. I'm sorry. Just do your best.
Thank you. Good evening. My name is Brian Leonard. I'm a school principal, so another educator, but my question actually isn't about education. It's about a question in addition to being a justice on the bench, but could you actually expound on some of the other roles as the role of the Chief Justice of the Supreme Court? Because I'm interested in the other aspects of your job that actually doesn't come in to the other things you mentioned earlier. Thank you.
Yes, the Chief Justice of Canada inherits a number of roles. One is chairing the Canadian Judicial Council, which is the body of all the Chief Justices and Associate Chief Justices of the federally appointed courts across the country, and it's responsible, among other things, for what is sometimes called judicial discipline, but with conduct issues relating to judges. This is a very important responsibility, but other things too. Relating to the functioning of the justice system. So we have meetings, very large meetings twice a year, and executive meetings at different intervals, and there are issues there. The Chief Justice is also head of the, chairs the NJI, which is the National Judicial Institute, which is an educational institute providing educational resources for judges, and that's an important and growing organization, and we're very glad to say that we are leaders in the world, really. I think I can say that without boasting, in the field of judicial education. The world is changing very rapidly, and we referred to technology earlier, but judges have to be kept up to date, and we strive to do this through the NJI. The Chief Justice also chairs the Governor General's Advisory Committee on the Order of Canada, which is an interesting duty. I suppose that on the statute, in the days when they set up the order, they thought that the Chief Justice would give an aura of credibility and assurance that the process was running well, and I think that I try to do that. I don't normally vote, but I try to make sure that the process runs well. There are meetings 2 or 3 times a year on that. I must say it's a gratifying experience because you see so many wonderful Canadians who've contributed in so many ways to their country, and not everyone gets it, but even among the files you read, that are ultimately not awarded the Order of Canada, the stories are immensely gratifying to read, and you realize what a wonderful country we have. Chief Justice, as well as the other justices, is also Deputy Governor General. That means that if the Governor General is unable to sign a document or out of the country to perform a duty, we may be asked to step in to do that duty. So those are some of the other things that we do.
we're probably now moving into our last question.
I'm an economist, and I like to measure things. Right? So I'm working on measuring outcome. So economists are moving from GDP to well-being. And if you want to answer a question like, is Canada becoming a more just society, what are the indicators we should look at?
If we want a more just society, what are the
Canada
indicators?
Is more just, I mean, it's becoming more just society compared to itself, like 5 years back. So
are we becoming a more just society?
Yeah, if you want to answer that question, what kind of indicator should we take into account?
Oh, well, I would refer you to the indicators that this World Justice Forum that I mentioned earlier has. You can go on their website, and they've developed a whole series of indicators for a good justice system, and there are a number of them. You know, there are things like lack of corruption, impartiality, access to justice, and there are many others. So it's quite a sophisticated business when you get around to actually trying to analyze this and put it on graphs. But they've done a pretty good job.
Well, thank you for that last question. Before I turn things back to Ashley, I'm trying to find the one question we could end with. And it's a tough one because you've given wisdom in so many different areas, from the courts to parenting. And I guess we have a mixture of ages of people in the room, some people just starting out in their careers and some people hoping for a fresh start in mid or late life, like myself. And I guess I just wondered, do you have a piece of advice as people think about how they would like to have an impact in their careers or in their communities? All of us are sitting inspired by all you've been able to accomplish and thinking, what should we have in mind as we think about charting our own paths in our careers or in our communities? And how might we hope to achieve that?
Well, it's very difficult to find one thing you could say, you know. I say choose your goals carefully, first of all. Really think about what's important to you. Try to put yourself a few years ahead, or maybe even at the end of your life, and say, did I really devote my energies and talents to what I should have, and what was worthwhile to me, what I would be best at, where I'd be able to make the greatest contribution. I would say that is quite important. Don't just let yourself slide into where the money is or where this or that is because it's easy. The other thing that I think is important, sometimes perhaps more important for women who have families and things, is I would say don't give up. I would say you'll have bad experiences and you'll have bad days, but you have to keep on, and you'll find that they will become fewer and fewer, and you'll have better and better days, you know. And I think that you need to also, if really bad things happen, be able to turn the page and just say, I'm not going to let that haunt me for the rest of my career or the rest of my life. I lost that trial. I'll never be a lawyer, da-da-da-da-da. That's not the way to think. You have to say, okay, I lost. Maybe I didn't do as good a job as I should have, but I'll learn from the experience and I'll move on. And that's not always easy. It's easy to say, but I think just persisting, even when you feel maybe you're not doing as well as you'd like to do, is sometimes, and in the face of difficulty and different demands, hanging in there is my advice. If you really want, if you figured out what you want to do, hang in there.
Well, that's great. So.
Ladies and gentlemen, not everyone has the opportunity to have an evening such as this in their lifetime. So please join me once again in thanking our speakers tonight. Thank you. I know I now can personally inform my 2-year-old a little bit more about what his grandfather does.